Proof beyond a reasonable doubt. Here's the definition that the judge just read you. Proof beyond a reasonable doubt is such proof as ordinary prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt that is based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. The law recognizes three standards of proof. The preponderance of the evidence is the first and lowest standard. Clear and convincing evidence is the next standard. And the third standard is proof beyond a reasonable doubt. And the way we lawyers sometimes illustrate what these three standards mean is through the scales of justice, right? The scales of justice equally balanced. When you apply the standard of the preponderance of the evidence, it's also called the scintilla of the evidence. A single grain of sand tips the scales in the favor of one party or the other. And this burden of proof is used in many civil cases. If the state wants to take away your driver's license, for an example, that is the burden of proof that the state has in that type of a case. They have to just ever so slightly convince the finder of fact that their evidence supports their action. The next standard is clear and convincing evidence. And that's pretty self-explanatory, right? It is clear evidence, and it convinces you, the finder of fact, that the action is correct. This is the standard of proof that is used if the state wants to take away your children. Clear and convincing evidence. It tips the scales more in the favor of one party over the other. The highest standard in this country is proof beyond a reasonable doubt. Proof beyond a reasonable doubt. Essentially, what the state has to convince you is that the evidence in this case completely eliminates any reasonable doubt, or in other words, leaving only unreasonable doubt. Capricious, fanciful. Capricious doubt, capricious means unpredictable. Fanciful, space aliens flew in, inhabited the body of Derek Chauvin, and caused this death. That's fanciful. Beyond the reasonable doubt. It is the highest standard in the law. Doesn't mean beyond all possibility of doubt, because I suppose space aliens may have been inhabiting his body, but that's obviously fanciful and capricious. So these two standards, the presumption of innocence and proof beyond a reasonable doubt, work in concert with each other. You start with the proposition that Mr. Chauvin is innocent of these charges. The state has to advance substantial evidence to convince you that the only doubts that are remaining are unreasonable doubts. As you analyze the evidence in this case, you would simply have to find that any defense that has been advanced is unreasonable. That's what this standard is all about. I want to take this opportunity also to talk to you about the importance of reading the entire instruction. Because I've seen, and lawyers, and I'm going to do it too, right? We pick and choose those things that help us make our case and help us argue our case. That's our job as lawyers. is to point out words and phrases within the instructions that make the difference in the case, and to take that evidence and present it to you in such a way that it supports our proposition. That's what we do. That's why you are instructed that if your memories of the evidence is different, that if the judge's law is what applies. But take the time to carefully read the entire instructions. Throughout the course of this trial, you've seen us do this, right? Little snippets. A second here, a second there, a screenshot here, a screenshot there. You need to review the entirety of the evidence in this case during the course of your deliberations as well. And I can tell you that some of the videos that we've seen, they're much longer than what was presented in court. There's additional information, and you're going to see some of that as we go through this case today. So take the time and conduct an honest assessment of the facts of this case, compare it to the law as the judge instructs you, and the entirety of the law. That's why the instructions tell you, consider the instructions as a whole. I've told you that lawyers like to present evidence that favors them, right? But we have to be intellectually honest about the evidence. We have to present it in an honest and intellectually cohesive and coherent manner. And I have to address something that I think is important. And I think it is a prime example of what I am asking you and what is your obligation to do to look at the evidence in light of all of the other pieces of evidence. Right? So you heard during the testimony of Dr. Fowler that one of the things that he considered is the possibility that carbon monoxide was present and could have contributed to an environment that created an oxygen deprivation. You heard that testimony. In rebuttal to that testimony, the state brought Dr. Tobin back in, and he told you, we can completely disregard that. We know as a fact, we know conclusively that Mr. Floyd did not have carbon monoxide because his oxygen was saturated to 98%. And you just heard the state say, just like I am right here, right? So it stands to reason. I could get up in front of you and I could argue to you, we know this wasn't asphyxiation because George Floyd had a 98% oxygen level. How could he have been asphyxiated at the hospital with a 98% oxygen level? But that's not intellectually honest. It doesn't stack up against the rest of the evidence because of what we know, right? We heard the testimony of Seth Bravender and Derek Smith, the paramedics. We heard the testimony of Dr. Langenfeld. They came in and they said they began resuscitative efforts. They introduced oxygen, an oxygen supply. They're manually breathing for him. They're re-oxygenating his blood. So when you look at that piece of evidence, when you look at a piece of evidence like that, you have to compare it against all of the other evidence. Because you can't come in and say, George Floyd, on one hand, George Floyd died of asphyxiation, but he has a 98% oxygen level. Right? His blood is oxygenated. Then stands to reason the opposite is true as well. You can't come in and say, I can conclusively prove that Mr. Floyd didn't have carbon monoxide in his blood because he had this high oxygen saturation. You test one statement against the evidence of other people and you compare. That is what you as jurors are obligated to do, And what I am asking you to do, compare the evidence against itself. Test it, challenge it, compare it to the law. Read the instructions in their entirety. Start from the point of the presumption of innocence and see how far the state can get. I submit to you that the state has failed to meet its burden of proof beyond a reasonable doubt. Mr. Chauvin has been charged, as the state indicated, with these 3 charges, and the judge has instructed you. Count 1 is second-degree murder while committing a felony. It's also called the felony murder rule in Minnesota. Kind of the textbook example is, I run into a liquor store, I pull a gun, I'm intending to rob the liquor store. My gun goes off, I shoot and kill the teller. I didn't intend to go in and murder that person, but the death of that teller occurred while I was committing a felony. That's the felony murder rule. He's been charged with murder in the 3rd degree for performing an intentional act that was eminently dangerous. Right? You've seen the instructions, you've heard them. And manslaughter in the 2nd degree. Again, the law has all the words, it defines the words you need, and the instructions should be considered in their entirety. Whenever I meet with a client, I try to explain what the elements are, and this is the analogy that I use. I say that a criminal case is kind of like baking chocolate chip cookies. You have to have the necessary ingredients. You've got to have flour and sugar and butter and chocolate chips and whatever else goes into those chocolate chip cookies. If you have all of the ingredients, you can make chocolate chip cookies. But if you're missing any one single ingredient, you can't make chocolate chip cookies. It's a simple kind of analogy. But the criminal law works the same way. We say, we call the ingredients the elements. The state has the burden of proving each and every element beyond a reasonable doubt. Not just some global proposition that they've proved their case beyond a reasonable doubt. They have to prove each of these elements beyond a reasonable doubt. And if you determine that they have done so, you convict. But if they are missing any one single element, it is a not guilty verdict. And you saw the spreadsheet that the state put up, right? The elements are a little different in each of these cases. And some of these elements will take less of your consideration. You will have to look at the evidence, and you will have to, for example, determine is Cup Foods in the city of Minneapolis, is Minneapolis in the county of Hennepin, is Hennepin County in the state of Minnesota? Did this happen on May 25th, 2020, right? It's going to take less of your consideration, but nevertheless, you have to do that. You have to go through that process. Two of the elements that I want to focus on during the course of my discussion here today, two of these elements are common throughout, or two of these issues are common and apply to all 3 counts. And so I want to focus my remarks today on those 2 issues. The first, were Mr. Chauvin's actions an authorized use of force by a peace officer, right? Because in the instructions, it specifically tells you no crime is committed if it was an authorized use of force. Period. End of discussion. The second is an element that is and does appear in all 3 counts. That is the cause of death. What caused Mr. Floyd's death? And we're going to talk about that second. So, let's start with the concept of reasonable force. As the instructions read in their entirety, No crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody. The kind and degree of force a police officer may lawfully use in executing his duties is limited by what a reasonable police officer in the same situation would believe to be necessary. Any use of force beyond that is not reasonable. To determine if the actions of the police officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the precise moment the officer acted with force. You must decide whether the officer's actions were objectively reasonable in light of the totality of the facts and circumstances confronting the officer and without regard to the officer's own subjective state of mind, intention, or motivations. The defendant is not guilty of a crime if he used force as authorized by law, and to prove guilt, the state must further prove beyond a reasonable doubt that the defendant's use of force was not authorized by law. So, you remember from my opening statements and how I talked about reason and common sense, right? The reasonable police officer standard. I want to just briefly add one thing here, is the standard is not what should the officer have done in these circumstances. It's not what could the officer have done differently in these circumstances. The standard is, what were the facts that were known to this officer at the precise moment he used force, and considering all of the totality of circumstances and facts known to the officer, what would a reasonable police officer have done? You have heard from numerous experts, police use of force experts, the training department from the Minneapolis Police Department. You've heard from police officers, street police officers, Sergeant Edwards, Sergeant Pluger, right? So you've heard from these people, and they have given you their opinions at various stages as to the reasonableness of the use of force. But one of the things that one of the things that all of these police officers effectively agreed to is that when you look at the question of what would a reasonable police officer do, knowing the facts of the case, there are things that a police officer is entitled to take into consideration above and beyond the facts, right? Their training, the training that they receive, their experience as a police officer, the department's policies on the use of force. And all of these things kind of lead into the question of, most critically, what are the facts that were known to the police officer, the reasonable police officer, at the precise moment the force was used? So you can start at a very high level, right? What were the reasonable police officer's knowledge of the area? Is this a high crime location? Is it a low crime area? Those are facts that a police officer would know. What are the specifics of the location of arrest, right? Am I going into a densely populated urban environment, or am I in a kind of a secluded backyard, right? Officer is calculating these pieces of information and assessing the risk, assessing the threats. Officers are entitled to kind of take into consideration things that you and I don't think about. Their tactical advantages, their tactical disadvantages. They can take into consideration the scene security, keeping the scene secure, and security of the scene, right? Those are two different concepts. So kind of, again, focusing back into what facts were known at the precise moment force is used, You can then take into consideration kind of this mid-range level of information. A reasonable officer wants to keep his fellow officers safe. A reasonable police officer takes into consideration the safety of civilians. The reasonable police officer takes into account the safety of the person that they are arresting. They take into account what resources do I have based upon how close am I to a hospital? What's the expected time if I call EMS? Because a reasonable police officer at times, they got to put the person in their squad car sometimes and take them because they're farther away. Calling for help, bringing help in would take longer than it would simply to take the person directly. And then you look at the direct knowledge that a reasonable police officer would have at the precise moment force was used. That includes information that they gather from dispatch, their direct observations of the scene, the subjects, and the current surroundings. They have to take into consideration whether the suspect was under the influence of a controlled substance. They can take into consideration, because again, this is a dynamic and ever-changing, just like life. Things change. It's a dynamic situation. It's fluid. They take into account their experience with the subject at the beginning, the middle, the end. A reasonable police officer tries to predict or is at least cognizant and concerned about future behavior based upon past behavior. But the unpredictability of humans factors into the reasonable police officer's analysis too. Because sometimes reasonable police officers take someone into custody with no problem, and suddenly they become a problem. It can change in an instant. A reasonable police officer will take into consideration his immediate surroundings. Are there bystanders? Are there civilians? A reasonable police officer will take into consideration who he is at the scene with. Are these veteran officers? Are they rookie officers? What do I know about my partners and my partner's abilities? So throughout the course of this trial, the state has focused your attention on 9 minutes and 29 seconds. The proper analysis is to take those 9 minutes and 29 seconds and put it into the context of the totality of the circumstances that a reasonable police officer would know. And the proper analysis starts with what would a reasonable officer know at the time of dispatch? Well, these are records that are kept. They've been introduced. You can look at them. This is Exhibit 151. This is the computer-aided dispatch report. You heard the testimony of Jenna Scurry, the 911 dispatcher. This is information that they are passing out to the officers. You will see that the initial information that a police officer has in his squad car, looking at his computer or hearing over the radio, is that on May 25th, 2020, at 20:02:13, so that's 8:02:13, a business, Cut Foods, who police officers have the obligation to respond to these calls, whether it be from a person or a business. But a citizen of the state of Minnesota, Minneapolis, runs a business and they called for assistance. And they told the officers, the reporting party, there is a male who provided a counterfeit bill to the business. He's 6 feet tall or higher. He's sitting on top of a blue Mercedes ML320 SUV. The license plate also appears this subject is under the influence. So the analysis of what a reasonable police officer would know in this circumstance is that a business is requesting its help, the suspect is still there, he's large, and he's possibly under the influence of alcohol or something else. So the analysis begins at 8:02 and 13 seconds. You may recall the testimony of Jenna Scurry as well, and it's not reflected in this exhibit pretty well, but in the evidence, exhibit number 10, you can hear the audio recording of the dispatch, Jenna Scurry to the officers. Jenna Scurry informed you that initially Officer Chauvin was assigned to this call on a Code 3 Priority 1 basis. It's Code 3, get their lights and sirens, get there fast, right? It's Priority 1 because the suspect is still on scene. So per the Minneapolis Police Department policy, get there fast, the person is on scene, right? That's what she testified. And then very quickly after that, that occurred at 8:04 and 28 seconds. Then what you see is what she told you, was that the sector car 320, that's the car that patrols this part of the city, said, hey, we can take this call, and Officer Chauvin and Officer Tao were canceled from the call. Right? So they were canceled from the call. And sector car 320, Officers King and Lane took it, and that occurred at 8:05 and 11 seconds. When Officer King and Lane took it over, you can hear, again, you can go back and you can listen to that audio of that dispatch, and you can hear them talking to each other. Officers King and Lane arrive at the Cup Foods at 8:08 and 20 seconds. So now we see police officers are responding. They're on scene at 8:08. Both Jenna Scurry and Peter Chang described that during the course of the initial interaction between Officers King and Lane and Mr. Floyd, through dispatch they heard what sounded like the sounds of a struggle. Jenna Scurry described she's trained to listen. She heard these sounds of a struggle, and she aired out on her own, other officers need to respond, Code 3, to assist Officers King and Lane, right? So a reasonable police officer is going emergent to a scene, he gets canceled from the scene, he's now being told that other officers need assistance, and step it up, get there fast. So you can see, again, based on the records, that at 8:10:08, 20:10:08, backed up 320 with 330. Right? So now 330 is Officer Chauvin and Tao. They're backing up Officer King and Lane. And you can see Peter Chang respond at 8:10 and 21 seconds. You hear 320 taking one out. So that means they're removing someone from the vehicle at 8:11:02. The scene is ultimately C4, Code 4, all clear at 20:12:21. So literally this demonstrates to you a couple of things. How quickly a situation can change from second to second, minute to minute. They went from get there fast, back off. Get there faster because someone needs help. It's clear. The situation is dynamic and it's fluid. They're provided with information that an officer needs assistance. They testified about the sound of a struggle, right? And if you recall, Sergeant Steiger specifically said all of this information would be known to a reasonable police officer. And it goes into and factors into the reasonableness of the use of force. Ultimately, Officer Chauvin and Officer Tao arrive at Cup Foods. Just pause this for 1 second here. Sorry. When we look at Officer, I just have to give you a little piece of information. When we look at Officer Chang's video, Officer Chang arrives first. You see the time is 1:16:33 Zulu. That's Greenwich Mean Time. Subtract 5 from 1 a.m. get you back to 8. So, Officer Chauvin and Officer Lane pull up. 8:16. Go over there.
Okay, let's stay put, all right? I don't want anybody near his car.
Information gathering in terms of this assessment and reassessment of, again, the decision-making process of a police officer, right? Don't come over here where I am, Officer Chang says. Go over there. They need your help. Because what at that point, at that precise moment, they don't know what's happening over at the squad car. They don't know that Officers King and Lane struggled with Mr. Floyd, getting him out of the car, that they sat him down, that they stood him up, that they walked over. They haven't seen any of this information, and there's no evidence to suggest that they have. So that doesn't factor into the information. Again, a reasonable police officer, what do they know? And they don't know that. But they're starting to get some indication, hey, go over there, right? Go over there. You can see right at about 8:17, and I apologize for the quality of the picture, Officer Chauvin is arriving and walking up to the squad car. So what would a reasonable police officer see in this instance? What a reasonable police officer would see could be defined, because again, a reasonable police officer has to be aware of his department policies, active aggression or active resistance. Let's call it active resistance. A response to police efforts to bring a person into custody or control for detainment or arrest. A subject engages in active resistance when engaging in physical actions or verbal behavior, reflecting an intention to make it more difficult for officers to achieve actual physical control. So as Derek Chauvin walks up to this scene, he has all of the information from dispatch. He has all of the information from Officer Chang, sending him over. He knows his department policy on the difference between active aggression, active resistance, passive resistance, based on policy, training, etc. This is an officer's consideration of, again, the use of force. All of these things factor into it. So what does he see? He sees Officers King and Officer Lane struggling with Mr. Floyd, attempting to put him into the car. He hears the words that Mr. Floyd is saying at that point. I'm claustrophobic. I'm a good guy. I'm a good man. I'm claustrophobic. I just had COVID, right? He's hearing this information. He's observing with his eyes. A reasonable police officer is observing this with his eyes and his ears and assessing what he sees pursuant to policy. And what he sees, at a minimum, is active resistance. Mr. Floyd's not just simply getting in the back seat of the car. So let's watch. What does Officer Chauvin see when he walks up? This is from his body camera from 8:17 and 21 seconds to 8:18 and 15 seconds. Just shy of a minute.
You can't win. I'm not trying to win. Don't get in the car. Don't get in the car. Don't get in the car. He knows it. He knows it was officer. Y'all hear me? Don't do me like that, man. Please. Okay, I thought you please. I was claustrophobic. I'm claustrophobic. Yeah, I'm claustrophobic, man. Come in the front. Please. I'm claustrophobic. I'm in the car. Okay? I'm not a bad guy, man. I'm not a bad guy. You ain't gonna win. Please. Please, man. Please. Hold on. You take the seat. Hold on. I can't choke. I can't breathe. Please. On this man. I can't take that, man.
By 8:18 and 15 seconds, Officer Chauvin has not laid a finger on Mr. Floyd, but he's observing. And a reasonable police officer is doing this. He walks onto a scene. He sees active resistance occurring, potentially active aggression occurring. He has two other officers. He has not intervened. But again, based on the policies and the training that you have seen, what were his options available to him at that time? If a person is actively resisting in the center, distraction techniques, controlled takedowns, conscious neck restraints. These are options available to Mr. Chauvin at this point. He has, per his training, these techniques at his disposal. A reasonable police officer would be making these observations. He would observe the white foam around Mr. Floyd's mouth. He would consider the possibility that this person was under the suspect or was under the influence of something. Basically, using the information from dispatch, making these observations, how is he analyzing this? How would a reasonable officer analyze this, and what would be known to a reasonable officer? The reasonable officer would look at the size of the person and assess that person's size in relation to his own size. Because it's a part of the risk-threat analysis, right, that we've heard about so much. A reasonable officer would know that these are two rookies putting this man in the car. In fact, the evidence established Mr. Chauvin trained one of the officers. So a reasonable officer may step back at this point to see if these two guys can get this under control. A reasonable officer will hear the words that the suspect is saying. I'm a good guy, I'm a good guy, I'm a good guy, I'm claustrophobic. And he's going to compare those words to the actions of the individual. Right? Because this is part of the analysis. Because I can say, I'm going to cooperate with you, I'm going to do whatever I want. But if my behavior is inconsistent with what I am saying, a reasonable officer takes that into consideration. In fact, a reasonable officer who's aware of his department policies knows the de-escalation policy that is in place. And part of what a reasonable officer has to do is to consider whether a subject's lack of compliance is a deliberate attempt to resist or an inability to comply based on these factors: medical conditions, mental impairment, developmental disability, physical language, language barrier, influence of drugs or alcohol, or a behavioral crisis. So a reasonable officer has to take the information and assess, is this suspect purposefully or intentionally, deliberately trying to thwart our efforts to take him into custody, or are they experiencing one of these other types of factors? But such consideration, when time and circumstances reasonably permit, shall then be balanced against the incident facts when deciding which tactical options are the most appropriate to resolve the situation safely. So again, reasonable officer, based on the totality of these circumstances, is going to take all of this information in, all of these policies, all of these training in, and a reasonable officer at that point would conclude that the amount of force that was being used by officers King and Lane was insufficient. It was not enough use of force to overpower Mr. Floyd's resistance to getting into the car. He's seen it, he's heard it, he's familiar with the policies, and so at precisely 8:18 and 15 seconds, Officer Chauvin goes hands on. Officer King, Officer Lane, and Officer Chauvin struggled, fought, whatever adjective you want to use. They struggled with Mr. Floyd from 8:18 till 8:19 and 12 seconds. About a minute, a little over a minute. It doesn't really seem that it's that long of a time, but again, the amount of physical exertion. Remember how Sergeant Jody Steiger described this. When the apparent attempts to get him into custody were futile. I wrote his quote down. The futility of their efforts became apparent. They weren't able to get him into the car. 3 Minneapolis police officers were not able to get Mr. Floyd into the car. They themselves are